My name is Renee, and I was 41 years old the afternoon I stood on the cracked sidewalk outside my childhood home and watched a sold sign get hammered into the front yard by a stranger. I hadn't listed it. I hadn't signed anything. I hadn't even had a single conversation with a real estate agent, and my sister Patrice had just sent me a text that said, and I will read this to you word for word because I saved it, I screenshot it, I have it to this day, don't be dramatic. I handled it. You'll get your half eventually. Eventually, that word sat in my chest like a stone dropped into still water. Because what Patrice didn't know what she had never bothered to check, never thought to verify, never once considered was whose name was actually on the deed to that house. And what I did after I found out? None of them saw it coming. Welcome to Composed Drama Stories, where the women everyone underestimated finally tell their side. If quiet strength and slow justice are your kind of evening, stay with me. So let me take you back before the sign, before the text, before the phone call that started all of it. 3 weeks before I stood on that sidewalk, I got a call from a number I didn't recognize. Area code I didn't know. I almost didn't answer. But something made me pick up. A man introduced himself as Dale Hutchins. He said he was a licensed real estate agent, calling to confirm the closing date on my mother's property on Sycamore Drive. He said it in that professional, practiced tone like he was reading from a checklist. Closing date. Property on Sycamore Drive. Confirm, I said. I'm sorry, what closing date? Silence, then. Are you not Renee Calloway? I said I was. He said, I was told you were aware of the sale. I told him I had never spoken to him a single day in my life. More silence. Longer this time. And then, very carefully, very cautiously, he said, Ma'am, I think you need to speak with your sister. I hung up and called Patrice immediately. She didn't answer. I called again. Nothing, third time. Nothing, fourth time. Straight to voicemail. Then the text came. Don't be dramatic. I handled it. You'll get your half eventually. I sat in my car in the driveway of my apartment building for a long time after that. Just sitting. Just breathing. Watching people walk past. Watching the ordinary world keep moving. The house on Sycamore Drive was the house my mother, Gloria May Calloway, had lived in for 31 years. She moved there when I was 10, and Patrice was 13. She painted the shutters herself. She planted a maple tree in the front yard that first spring, barely taller than I was at the time, that grew into something magnificent over the decades. She sanded the back porch floor 3 times over the years, until it was smooth enough to walk on barefoot. That house was not just a property. It was 31 years of a woman's life. It was every holiday and every argument and every Saturday morning and every thunderstorm. Mom passed in February, 7 months before Dale Hutchins called me. Ovarian cancer diagnosed in October of 2021, gone by February of 2023. 14 months. That's the kind of timeline that is just long enough to teach you every variation of helplessness, and still feel like it ended too soon. She had been very clear in those last months about what she wanted for us. She said it more than once. She sat in that living room on Sycamore Drive, in the chair closest to the window, wrapped in the blue knit blanket her church group had made her, and she said, You two are all each other has now. Promise me you won't fight over things. We promised. I meant it. I want to tell you about my mother before I go any further, because she is the heart of this story even though she is gone. Gloria Calloway was a medical billing clerk for 26 years. She worked for the same hospital system her entire career, starting as a file clerk and retiring as a senior coding specialist. She understood paperwork the way some people understand music, naturally, completely, without having to think about it. She read documents the way other people read novels. She kept files on everything. Insurance policies, receipts, warranties going back 15 years, school records for both of us, tax returns in chronological order in labeled folders going back to 1988. She had a system. She always had a system. There was the plastic accordion folder in the glove compartment of her car, everything related to the vehicle, registration, insurance cards, service records. There was the accordion folder in the kitchen drawer, utilities, appliances, anything related to the house's maintenance. And then there was what she called the just-in-case folder, thick manila envelope, sealed with a rubber band, living on the top shelf of her bedroom closet behind her winter sweaters. She mentioned it once, maybe twice, over the years. Everything important is in the just-in-case folder, she'd say. And then she'd move on to something else. I thought about that folder a lot in the months after she died. Mom was not a wealthy woman. She raised 2 daughters on a billing clerk's salary after my father left when I was 6. She drove used cars. She bought clothes on sale. She took one vacation that I can remember, a long weekend in Gatlinburg when Patrice and I were teenagers, where we stayed in a cabin that smelled like pine, and she let us stay up late playing cards. She didn't complain about any of it. She just worked. She just kept going. The house on Sycamore Drive was her single largest asset in this world. And she paid it off in 2019. The final mortgage payment. I was sitting at her kitchen table. That afternoon I had stopped by with groceries when she called the mortgage company to make that last payment. I watched her face while she was on hold, and when the representative confirmed the balance was 0, I watched something shift in her expression. Relief, pride, something deep and private. She hung up and she looked at me and she said, "Renee, baby, I own something." Like she still couldn't believe it, even as she said it. I cried a little. She waved her hand at me like I was being ridiculous. That was 2019. 2 years before the diagnosis. 2 years before everything changed. Now, Patrice, my sister, is 3 years older than me. 44 now. She has always been the one who fills a room louder, faster, more certain of herself than anyone else present. When we were growing up, I admired that about her. I thought it was a kind of confidence I just didn't have. It took me until my mid-30s, sitting across from a therapist in a beige office, to name what Patrice actually had. It wasn't confidence. Confidence is quiet. It doesn't need an audience. What Patrice had was something closer to entitlement, the unshakable belief that her version of events was the correct one. Her decisions were the right ones. Her read on any situation was the one that counted. She married a man named Greg Donovan, became Patrice Donovan, moved to a suburb called Millhaven, about 40 minutes from Sycamore Drive. They have 2 teenagers, a house they refinanced twice, and a life that always looked slightly more expensive than it probably was. When Mom got sick, Patrice was present in the way that some people are present, loudly, briefly, and on her own schedule. She came to the initial oncology appointment. She made some calls to ask about treatment centers. She cried on the phone with me and said she couldn't believe this was happening. And then, as the months went on, and the reality of it settled in the chemo schedules, the bad days, the slowly shrinking world of someone who is seriously ill, Patrice's presence got thinner. I don't want to spend too much time on this, because it still makes me sad more than angry. But the truth is, I was there. Twice a week, minimum, sometimes more. I learned which of Mom's nurses were thorough, and which ones rushed. I learned which anti-nausea medications worked and which ones made her sicker. I learned how she liked her pillows arranged when she was having a bad day, two behind her head, one under her knees. I learned that she wanted to watch old game shows when she felt too bad to do anything else, and that she wanted the window open even in winter because the cold air helped with the nausea. Patrice came when she could. I understand that people have lives, but I also know that Mom noticed. She never said it directly to me, but I saw it in the way her face changed when I walked in versus when Patrice walked in. With me, her shoulders dropped. With Patrice, she put on a smile that was a little too bright. Mom died on a Tuesday morning in February. I was in the room. Patrice arrived about 2 hours later. The funeral was small, the way Mom had wanted. The reception afterward was at Sycamore Drive, because that's where she would have wanted it. Her church friends came, some people from her old job, a couple of neighbors. Patrice and I stood in that living room together and accepted casseroles and hugs, and I remember thinking, at least we have this. At least we're still standing in the same room, on the same side of something. In the weeks after, Patrice and I talked a handful of times about the house, what to do, whether to sell, whether to rent, whether one of us wanted to buy the other out. Those conversations went in circles. Nothing was decided. At least nothing that I knew about. Because what I didn't know, what I would only find out much later, was that Patrice had already started making her own plans. In March, 6 weeks after Mom's funeral, while I was still going to Sycamore Drive by myself to sort through 31 years of our mother's belongings, still washing dishes and folding sweaters and trying to figure out how a person decides what to keep and what to let go of, Patrice had already called 3 real estate agents. She had gotten 2 separate appraisals done on the property. She had settled on an agent, Dale Hutchins, and told him she was ready to move forward. She had not told me a word of it. The reason Patrice thought she could do any of this, the reason she believed she had the authority to act alone, came down to an assumption. She assumed the house was in Mom's name only. She assumed that since they were both named in the will as heirs, they had equal legal standing to make decisions about the property. She thought this was a 50-50 situation. She thought her 50% was enough. She had never checked the deed. She had never looked at the actual document. She had just assumed. I found all of this out later. I'll tell you how. After Dale Hutchins called me after that text from Patrice, I drove to Sycamore Drive. I parked in front of the house and just sat there. The yard was tidy. The maple tree had its full summer canopy. The porch swing was still there, moving slightly in the breeze. And the sold sign stood in the front yard like something from a bad dream, red and white, and completely out of place. I sat in that car and I thought about what Dale had said. He'd called to confirm a closing date. That meant a contract was already signed. That meant a buyer had already agreed to a price. That meant Patrice hadn't just made a few phone calls. She had taken this all the way to a signed purchase agreement without a single word to me. I thought about Mom. I thought about what she would do in this moment. She would not cry in the car. She would go find the paperwork. I drove home. I went to the storage boxes I had brought from Mom's closet after she died. 3 boxes, packed carefully, labeled in my handwriting. Documents, keepsakes, bedroom closet, top shelf. I found the just-in-case folder in the 3rd box. I sat on my living room floor and opened it. It took me about 40 minutes, going through each document carefully, before I found what I was looking for. A warranty deed, recorded with Holt County in 2019, the year Mom paid off the mortgage. I read the grantee section, not just Gloria May Calloway. Gloria May Calloway and Renee A. Calloway, joint tenants with right of survivorship. I read it again, And again. I set the document down on the carpet in front of me and I just stared at it. Mom had added my name to the deed. In 2019, the same day I would later confirm that she made her final mortgage payment. She had gone to the county recorder's office, alone, and she had filed a new deed with both of our names on it. She had never mentioned it to me. She had clearly never mentioned it to Patrice. I picked up my phone and I looked up what joint tenants with right of survivorship actually meant in plain terms, because I wanted to be absolutely certain before I did anything else. I needed the exact definition in front of me before I could trust my own understanding. Here is what I found. Joint tenancy with right of survivorship means that both people named on the deed own the property together, not as separate halves, but as a whole, shared between them. And when one of the joint tenants dies, ownership of the entire property passes automatically to the surviving tenant. Not through probate, not through a will, just through the deed itself, by operation of law. Mom had died. I was the surviving joint tenant. The house on Sycamore Drive belonged entirely to me. I need you to understand what happened inside me in that moment, because it was not what you might expect. There was no triumph, no rush of satisfaction. The first thing I felt, the very first thing, was grief. A fresh wave of it, specific and sharp. Because I understood what this meant. I understood what my mother had done. In 2019, the year she paid off her house, she had looked ahead into a future she couldn't fully see, and she had done something about it. She had protected me. Without telling me, without making a production of it. She had just gone to the county office and filed a form. She knew Patrice. She knew how Patrice operated. She had never said so to me directly. She was too careful for that, too loyal to the idea of family to speak ill of her own daughter. But she had seen enough, understood enough, to make a decision, and she had acted on it quietly, the way she did everything important. I sat on my living room floor and I cried for a long time. Then I got up. I got a glass of water. I sat at my kitchen table with the deed in front of me, and I started thinking about what needed to happen next. Because this was not over. Patrice had signed a purchase agreement with a buyer. There was a closing date scheduled. A real estate agent was involved. A buyer was involved. A buyer's agent was probably involved. People were expecting a transaction to complete. And Patrice believed completely, confidently, in the way she believed most things, that she had every right to do what she'd done. I needed to be careful. I needed to be thorough. The next morning, I called a real estate attorney. I got the name through a woman at my job, Karen, whose family had gone through a property dispute the year before. She'd mentioned her attorney more than once and always spoke highly of her. The attorney's name was Sandra Okafor. I called her office when it opened at 9. Her assistant put me through within minutes. I explained the situation to Sandra, the deed, the joint tenancy, the phone call from the agent, the signed purchase agreement, all of it, in about 4 minutes. Concise, the way my mother would have done it. Sandra said, "Can you send me a photo of that deed right now, while we're on the phone?" I took a picture and sent it. She was quiet for a moment. Then she said she'd call me back shortly. She called back in 18 minutes. She said, "Renee, your sister has no authority to sell this property. None. Her name is not on this deed. Yours is. As the surviving joint tenant, you are the sole legal owner of this property. The purchase agreement she signed is not binding on you because she did not have the legal authority to enter into it on behalf of the property." I said, "What do we do?" She said, "First, we send a letter." Sandra Okafor drafted a cease and desist letter that went out the following morning, sent by certified mail and email simultaneously to 3 parties: Patrice M. Donovan, Dale Hutchins of Hutchins Realty Group, and the buyer's agent whose information Sandra obtained from the listing. The letter was precise and formal. It stated that the property at 400-114 Sycamore Drive was owned solely by Renee A. Callaway as the surviving joint tenant of record, per a warranty deed recorded with Holt County in 2019. It stated that no person other than Renee A. Callaway had the legal authority to enter into any contract for the sale or transfer of said property. It stated that the purchase agreement signed by Patrice M. Donovan was entered into without legal authority and was therefore not binding on the property owner. And it stated that any attempt to proceed with the scheduled closing would constitute an attempt to transfer title without the owner's consent, exposing all parties to significant civil liability. It went out on a Thursday afternoon. By Friday morning, I had 3 missed calls. Dale Hutchins, an unfamiliar number that turned out to be the buyer's real estate attorney. And Patrice. I did not return any of them that day. Not because I was being petty, though I understand if it sounds that way, but because Sandra had counseled me carefully. She said, Patrice may attempt to contest the deed. She could claim it was fraudulent. She could claim Mom lacked legal capacity when she signed it. She could claim I had exercised undue influence over Mom to have my name added. These were the standard challenges to a deed transfer, and we needed to be prepared for all of them before I engaged directly with my sister. So instead of calling anyone back, I built the record. I went back through every document in those storage boxes. I found the original deed transfer paperwork from 2019, not just the deed itself, but the filing receipt from the county recorder's office, time-stamped. I found the name of the notary whose stamp appeared on the deed. Patricia Elaine Forsyth, Notary Public, Holt County, Commission Number 48221. I called the county recorder's office and requested a certified copy of the recorded deed. They told me it would arrive within 4 to 5 business days. Then I searched for Patricia Elaine Forsyth. She wasn't hard to find. She operated a small notary service out of her home in the eastern part of Holt County, still active. I called her on a Tuesday afternoon. She answered on the 3rd ring. I explained who I was and why I was calling. I told her my mother's name, Gloria May Callaway, and the date of the deed transfer. There was a brief pause. Then Patricia Forsyth said, "Oh, yes. I remember her. She said my mother had come in alone. No one with her. She had the paperwork already prepared. She had clearly done her research before coming, because she knew exactly what she was filing and why." Patricia Forsyth said my mother had read every word of the deed before signing it, had asked her twice to confirm the language around the joint tenancy, had asked what right of survivorship meant in plain terms, listened carefully to the explanation, and then said, "Yes, that's exactly what I want." Patricia Forsyth said, "Your mother was one of the most deliberate people I've dealt with. She knew precisely what she was doing." I asked if she would be willing to put that in a written statement. She said, "Absolutely, send me an email with the details and I'll have something to you by end of week." Her written statement arrived in my inbox 4 days later. 3 paragraphs. Clear, specific, professional. She described the date, the circumstances, my mother's demeanor, the questions she asked, and her conclusion that Gloria Callaway had been fully competent, fully informed, and fully intentional in her actions. The certified deed copy arrived from the county recorder 2 days after that. Now I had the deed itself, the filing receipt, the notary's written statement, a certified county copy, and the name of a real estate attorney who had reviewed it all and confirmed my ownership. I also needed to understand exactly what Patrice had done and exactly what representations she had made to Dale Hutchins. I called Dale back the following Monday morning. He answered immediately, and his tone told me everything. He was cooperative in the way people are cooperative when they are worried about their own liability. He told me that Patrice had first contacted him in early March. She had called him, explained that she and her sister had inherited a property and they wanted to sell, and that she was authorized to handle the transaction. He had asked if there was a will. She had provided a copy of the will, which named both daughters as heirs. He had accepted that as sufficient authorization to proceed. He had not ordered a title search before taking the listing. I let that sit for a moment before I responded. The reason that mattered is this. A title search would have revealed the deed transfer in 2019. It would have shown that the property was in joint tenancy and that the survivorship had passed full ownership to me. A competent agent running a standard title search before listing the property would have caught this immediately. Dale Hutchins had skipped that step. And as a result, he had listed a property, found a buyer, negotiated a price, and signed a purchase agreement, all based on authority that did not exist. He was, as Sandra would later describe it, a man with significant motivation to be helpful. He provided me a full written timeline via email. First contact from Patrice, March 11th. First appraisal completed, March 22nd. Listing agreement signed, April 4th. Second appraisal for comparison, April 19th. Listed on MLs, April 28th. Offer received and accepted, June 3rd. Purchase agreement signed, June 17th. Closing date scheduled, August 2nd. 4 months. Patrice had been running this operation for 4 months. Making decisions, signing documents, coordinating with professionals, all of it. None of it shared with me. None of it within her legal authority. Sandra requested copies of the listing agreement and the purchase agreement from Dale as part of our formal correspondence. He provided them without hesitation. I read both documents carefully. On the listing agreement, Patrice had signed her own name. Not Mom's name, her own. In the line for owner authorized seller, she had written, Patrice M. Donovan, heir to the estate of Gloria M. Calloway, deceased, not forged. But a significant misrepresentation. She had claimed authority she did not have, in writing, in a legally binding contract. The purchase agreement said the same. Sandra reviewed both and said what I had already suspected. At minimum, negligent misrepresentation. She either didn't know she lacked the authority, which reflects a failure to do basic due diligence, or she did know and proceeded anyway, which is worse. She told me it would be my choice, how far I wanted to pursue it. The priority right now was the property. Everything else could wait. Nearly 2 weeks had passed since the cease and desist letter when I finally called Patrice. She had called me 11 times, texted 8 times. The texts ran a wide emotional range: anger first, then explanation, then something close to panic when the buyer's attorney apparently contacted her directly. I waited until I had everything in order. The certified deed, the notary statement, Sandra's formal review, Dale's timeline, copies of both contracts. I called on a Wednesday evening. She picked up before the second ring. She started immediately. She said she had done this for both of us. She said the house was just sitting there, and it didn't make sense to leave it empty and pay property taxes on it indefinitely. She said she had tried to talk to me about selling it, and I hadn't engaged with the conversation seriously. That was not true. We'd had vague discussions that went nowhere, and no decision had been made by either of us. She said she thought she had every right to move forward because they were both heirs. She said she had talked to someone about it, she didn't say who, and been told that heirs had equal standing. She talked for a long time. I let her. When she finally stopped, I said, "Patrice, I need to tell you something about the deed." Silence. Mom added my name to the deed in 2019. Joint tenancy with right of survivorship. Do you know what that means legally? No answer. It means that when Mom died, I became the sole owner of that house. The entire property. Your name is not on the deed. It never was, and the will doesn't change that joint tenancy supersedes inheritance law. The property never went through the estate. It passed directly to me. I heard her breathing. Then, that can't be right. I have the certified copy from the county recorder's office. I have the original notarized deed. I have a written statement from the notary who witnessed Mom sign it. She came in alone, Patrice, without me. She did it by herself. And I have an attorney who has reviewed everything. A long silence. Then Patrice said, "Mom would never do something like that without telling me." I said, "She did." More silence. And then, quietly, something I didn't expect. Why would she do that? I held the phone. I thought about how to answer. I thought about the chair by the window and the blue blanket and the way Mom's face looked when I walked in versus when Patrice walked in. I said, "I think you know why, Patrice." Neither of us spoke for a moment. Then I told her what was going to happen. The sale would not proceed. The buyer was being notified through their attorney. The closing date on August 2nd was canceled. Sandra was filing paperwork with the county to formally establish the title as clear in my name. Dale Hutchins had already been notified that he had no basis to continue as listing agent. All parties had been informed. Patrice said, "So you're just going to take everything?" I said, "I'm not taking anything. Mom gave it to me. In 2019. In writing. With a notary present and a county recorder's stamp." She said, "This isn't over." And I said, "Patrice, I hope it is. I really do. I meant that. I meant it then, and I still mean it." But it wasn't over. About 3 weeks after that call, Sandra received a letter from an attorney named Kevin Pratt, writing on Patrice's behalf. The letter raised 2 formal legal challenges to the deed. First, that our mother had lacked legal capacity at the time she signed the deed transfer in 2019. Second, that I had exercised undue influence over Mom to cause her to add my name to the deed. I want to be honest about what it felt like to read those allegations. The capacity argument, the claim that Mom hadn't understood what she was signing, that hit differently than a legal threat. That was a statement about my mother's mind. It was saying she was confused, or compromised, or didn't know what she was doing on the day she made one of the most deliberate decisions of her life. That felt like a second loss of her, in a way. Someone trying to take away her agency, even after she was gone. And the undue influence claimed the implication that I had somehow manipulated my mother into doing this, that one I had to sit with for a few days before I could even discuss it calmly. The idea that the extra trips I made to Sycamore Drive, the medications I kept track of, the hours I spent in that house, that any of that could be reframed as manipulation. I had to breathe through that one. Sandra was measured. She'd seen these arguments before. She said both were weak. And here's why. The capacity claim had a fatal problem. The deed was signed in 2019. Our mother's cancer diagnosis was in October 2021. That was a gap of more than 2 years. There was no illness in 2019. There were no medications, no cognitive effects, no medical reason whatsoever to question her capacity at the time of signing. And the notary's written statement described a woman who was sharp, deliberate, and thorough. Patrice would need medical evidence showing impairment in 2019, and there was none to find, because there was none to have. The undue influence claim had an even simpler problem. I wasn't there. Mom had gone to Patricia Forsyth's notary office alone. She had not told me she was going. She had not asked for my help with the paperwork. She had done the entire thing independently, without my knowledge. Undue influence requires that I was present and applying pressure. I was not present. I didn't even know this happened until I read the deed in my living room 7 months after my mother died. Sandra said, "Let's not just defend this. Let's go on offense." We filed a petition in Holt County Circuit Court to quiet title on the property. A quiet title action, in plain terms, is a lawsuit asking a court to formally confirm who owns a piece of property and to eliminate any competing claims. It puts everything on record, officially, so that the ownership is clear beyond dispute. We filed the petition with the following attached: the original warranty deed, the certified county recorder's copy, the time-stamped filing receipt from 2019, Patricia Forsyth's written notary statement, a timeline prepared by Sandra documenting every relevant event, and a legal brief laying out why the 2 challenges raised by Kevin Pratt had no basis in law or in fact. We requested an expedited hearing given the attempted sale. Kevin Pratt filed a response on Patrice's behalf. It restated the 2 challenges' capacity and undue influence. It contained no supporting evidence, no medical records, no witness statements, no documentation of any kind to support either claim. Because there was nothing to provide, the evidence didn't exist. The hearing was set for a Tuesday morning in September. Holt County Circuit Court, Courtroom 4B, 7th floor. I drove there alone. I wore a navy blazer. I brought my folder with every document in it, organized by date, tabbed, the way my mother would have organized it. I arrived 20 minutes early. Sandra was already there. We sat at the petitioner's table, and I set my folder down, and I folded my hands on top of it, and I sat still. Patrice came in about 5 minutes before the scheduled time. Kevin Pratt was with her, a compact man in a gray suit, carrying a slim briefcase that told me everything I needed to know about how much evidence he had. Patrice and I made eye contact once, across the room. I didn't look away. After a moment, she did. The Honorable Diane Carruthers took the bench at 9:15. She was methodical and unhurried. She had clearly read the filings in advance. She didn't fumble with pages or need to orient herself. She reviewed the deed, reviewed the notary statement, reviewed the certified county records, reviewed Sandra's brief. She asked Sandra 2 specific questions. One about the exact language of the survivorship clause, and one about the date the deed was recorded relative to the date of death. Sandra answered both precisely and without hesitation. Then, Judge Carruthers turned to Kevin Pratt. She asked him what evidence he intended to present to support the claim of lack of capacity in 2019. He said they did not have medical records from 2019 to present at this time, but that they believed a full discovery process would likely surface relevant documentation. The judge looked at him steadily. She said, "Counsel, the deed was executed in 2019. The decedent's illness began in 2021. You are asserting diminished capacity with a 2-year gap between the signing and the onset of illness, and no medical evidence. What is the factual basis for this claim?" Kevin Pratt said they had reason to believe additional records might exist. Judge Carruthers said, "Might exist is not a legal standard. "Counsel," she asked him about the undue influence claim. He said the petitioner had been the primary caregiver in the last years of the decedent's life, and that this created an environment in which influence could have occurred. The judge noted that the deed had been executed in 2019, 2 years before the caregiving arrangement he described, and asked how that timeline supported his argument. He didn't have a satisfying answer. She ruled from the bench. She didn't wait for a written order. She said it then, in that room, in front of everyone. Judge Diane Carruthers granted the petition to quiet title. She confirmed that the property at 414 Sycamore Drive, Holt County, was the sole legal property of Renee A. Calloway, as surviving joint tenant of record per the warranty deed filed with Holt County in 2019. She found no credible basis for the claims of diminished capacity or undue influence, noting the absence of any supporting evidence for either claim and the significant temporal gap between the deed's execution and the decedent's illness. She found that the deed had been properly executed, witnessed, notarized, and recorded in accordance with the applicable laws of the state. She also awarded attorney's fees to me. In plain terms, the court ordered Patrice's side to cover my legal costs, because the challenge had been brought without legal or factual basis. I want to tell you what that moment felt like, because it wasn't what you'd expect. There was no surge of adrenaline, no urge to look over at Patrice's table, no feeling of winning, exactly. What I felt was something quieter than that, something settling. Like when you've been holding a door closed against the wind for a very long time and someone finally latches it properly from the other side. Just stillness. The thing was done. Sandra put her hand briefly on my forearm and said, quietly, "Renee, that's it." I nodded. We gathered our papers. We walked out of courtroom 4B and down the hallway to the elevator and out of the Holt County Courthouse into September morning air that was just starting to carry the first suggestion of fall. I stood on the courthouse steps for a moment. I didn't call anyone. I didn't text anyone. I just stood there in the morning light and let it be what it was. I want to tell you what I did with the house. I kept it. I'm not ready to decide its future yet, and I've given myself permission not to be. What I do is go there on Saturday mornings. I have a key. I let myself in through the back door because the back door sticks slightly and you have to lift the handle while you turn it. And I know how to do that. I make coffee in Mom's kitchen, in her old drip coffee maker that makes exactly 4 cups at a time. I sit on the porch swing with my coffee, and I watch the maple tree. In September and October, it was extraordinary deep orange and red, leaves coming down in waves on windy days, covering the front yard in something that looked almost deliberate. I don't know yet if I'll sell it. I don't know if I'll rent it. I don't know if someday I'll want to live there myself. What I know is that it doesn't have to be decided today. It doesn't have to be anything other than what it already is, a place where a woman lived and worked and raised her children and paid off her mortgage and sat in a chair by the window and watched the yard she'd planted and maintained for 31 years. A place she loved, a place she protected. Patrice and I have not spoken since the hearing. I don't know if that's permanent. I genuinely don't know what I want from her, or whether I want anything. I think about the fact that she's my sister. I think about the fact that we stood in that living room together in February and accepted casseroles from people and told each other we'd be okay. I think about the promise Mom asked us to make. I also think about the 4 months of phone calls and listings and contracts and appraisals that Patrice ran behind my back while I was sorting through 31 years of our mother's belongings, 1 box at a time. I think about the text. Don't be dramatic. You'll get your half eventually. I don't know how to hold all of that at once and still see a way forward. Maybe someday I will. I'm not there yet. What I keep coming back to is this. We talk about family like it's a kind of armor. Like saying the word, she's my sister, he's my brother, we're family, creates a kind of protection that other relationships don't have. And I believed that. I think most of us do, for most of our lives, until the moment we learn that we were wrong. The truth my mother knew, that she didn't teach me in words, but wrote out in a form at the county recorder's office in 2019, is simpler and harder than that. Love is real. Love matters. But love is not a legal instrument. Love does not file itself with the county. Love does not get notarized or recorded or certified or ruled upon by Judge Diane Carruthers on a Tuesday morning in September. What protects you is the document, the deed, the record. The thing that exists in a file drawer or a just-in-case folder or a county archive, independent of how anyone feels about anyone else, independent of who shows up and who doesn't, independent of who talks the loudest and who moves the fastest. My mother was not a dramatic woman. She was not given to grand gestures or speeches about legacy. She was a woman who understood paperwork. And she used that understanding quietly, privately, without telling anyone to make sure that whatever came after her, one person would be protected. She did the quiet work. She always did the quiet work. And the lesson I carry out of all of this is not about revenge, and it's not about winning. It is about paying attention to the quiet work that the people who love you do when no one is watching. It is about understanding that real protection rarely announces itself. It sits in a just-in-case folder on the top shelf of a closet, waiting for the moment you need it. The people who truly love you prepare for your future in the present, and you may not know it until the day it saves you. Honor that. Notice it. And when you can do it for someone else. If this story reached you somewhere true, if you've been the one who showed up, the one who did the work without credit, the one someone else underestimated, share it with someone who needs to hear it tonight. Drop a comment and tell me what you would have done, or what you wouldn't change. And if you haven't already, hit subscribe. I'll be here. I'll have another story. I'll see you in the next one.